Chapter 12. Information to the police and their power to investigate. Section 154 to 176. In the first, information of an offense is cognizable and the other is non-cognizable, whole case shall be deemed to be cognizable case. Point out the incorrect answer. First information report means it must always be given in writing is incorrect. Which one is correct is report about cognizable offense, information given to the police officer, information first to point of time. In reference to the information relating to the commission of cognizable offense, which one of the following statement is not correct? D is not correct. It may be given oral to an officer in charge of a police station. It is reduced in writing or under the direction of officer in charge of police station. Information reduced to writing is to be signed by the person giving it. First information report relate to prima facie of cognizable offense. First information report under section 154 is related to only a cognizable offense. According to the CRPC, every information relating to the commission of cognizable offense shall be signed by the person giving it. Information regarding the occurrence of the cognizable offense is recorded by officer in charge of a police station under which provision of CRPC 154. An aggrieved informant on refusal on part of officer in charge of police station to record information regarding cognizable offense may send in writing substance of information by post to the superintendent of police. Any person aggrieved by refusal on the part of officer in charge of a police station to record the informant in cognizable offense may, under section 154 subclause 3, the Code of Criminal Procedure, send the information in writing and the post to superintendent of police. FIR can be filed under which section of CRPC 154? Who out of the following may investigate a cognizable cases even without the order of magistrate in charge of a police station? Any person aggrieved by the refusal on the part of officer in charge of a police station to record information relating to the commission of cognizable offense may send the substance of such information in writing and post to superintendent of police concerned. The first information report means information relating to the commission of cognizable offense given to the officer in charge of a police station. FIR is registered under which one of the following section? 154. First information report is not a substantial evidence. It can be during a trial of the following: both only to the corroborated the evidence of informant, only to the contradict the evidence of the informant. Which one of the following is not essential element of the FIR? D is not important essential, ABC is important essential. It is the information given to the police officer. Information must be related to the cognizable offense. It is the information first in point of time. Which one of the following statement is correct? A police officer has power to take the signature of the informant in the FIR, first information statement. Under CRPC, who shall record the information of the rape being given as a rape victim? Woman police officer of any woman officer. Woman police officer or any women officer. In relation to FIR laws under section 154 of CRPC, which one of the following statement is not correct? It cannot be used by a previous statement for any purpose. Which one of the following is landmark case on the FIR? Lalit Kumari versus State of UP. Which one of the following is a provision of Criminal Procedure Code gives statutory definition of FIR? Not defined. If any officer in charge of the police station refused to register, if an officer in charge of a police station refused to register FIR, to whom the substance of it should be sent as per section 154 of CRPC, Superintendent of Police. A person aggrieved of refusal, an officer in charge of police station to record the information referred to subsection 1 of section 154 of CRPC may, under subsection 3 of section 154, since the substance which information through post in writing to the Superintendent of Police concerned, the investigating officer shall within 24 hours of the arrest of the person transmit to the nearest judicial magistrate a copy of the entries in the diary relating to that case along the accused if the investigation is not complete within 24 hours. Which one of the following is not essential element of the FIR? B. It is an information given to police officer. It is an information first in point of time. Information may related to kind of offense, whether cognizable or non-cognizable. A case which include cognizable offense and non-cognizable offense is cognizable case. As such, the investigation of the case does not require any sanction of the magistrate. A complaint became FIR when it is sent to a police for investigation under section 156 clause 3 of CRPC. If a woman against whom the offence under section 326A IPC is alleged to have been committed give information under CRPC, such information should be recorded by a women police officer or any women officer. The power of the magistrate to detain a person for the purpose of police investigation is for the maximum period of 90 days. When the investigation can't be complete within the 24 hours, depending upon the facts and circumstances, of each case, magistrate can order a person to remain in custody for all of the above: 15 days, 90 days, 60 days. Permission to investigate into non-cognizable offence can be granted by magistrate having power to try the cases or commit to cause for trial. No police officer can investigate a non-cognizable case without the order of the magistrate having power to try such case to commit the case for trial. Permission to investigate into non-cognizable offence can be granted by a magistrate having power to try the case or commit the case for trial when the information regarding the commission of non-cognizable offence is given to the officer in charge of a police station, he shall none of the above. In case of information of non-cognizable case, a police officer is bound to enter the information in his diary and refer the informant to the magistrate. In non-cognizable case, the investigation starts after obtaining order from concerned magistrate. Which one of the following cannot arrest by the police without warrant? Person accused of non-cognizable offence. In cognizable offence, police officer has power to arrest without warrant and investigate the case without the order of the court. Which one of the following statement is true? A magistrate can order investigation under section 156 clause 3 of crpc even though offence is exclusively trial by session court. The power to direct investigation under section 156 clause 3 of crpc is exercised by a magistrate. A magistrate has power to direct the police to investigate into the offence of crpc under section 156 clause 3 of crpc. Investigation under crpc is conducted by a police officer only. Investigation include all the proceeding conducting by police officer for the collection of evidence. The investigating officer is bound to reduce in writing any statement made to him in the course of examination under section 161 of crpc? No. Under crpc, the object of investigation is to collect the evidence against the accused. Object of investigation is to collect the evidence. Which one of the following statement is correct in relation to power of magistrate under section 156 clause 3? He may direct the officer in charge of a police station to conduct the investigation into the police without recording any reason for doing so. When a report is forwarded by police under section 173(2)(1) with conclusion that the offence appeared to have been committed by a particular person or person, which of the following course would not be open to the magistrate? To direct further investigation under section 156 clause 3 and require the police to make further report. Under which provision of crpc receipt FIR report for the commission of an offence, the officer in charge of a police station will send a copy to the concerned magistrate under section 157 clause 3, 157 of crpc. In a cognizable case under IPC, police will have all the power to investigate, including the power of arrest without warrant. When an investigating officer bound to videograph the proceeding during investigation, identification of driver of the offending vehicle be physically disabled victim of the road accident, recording of the statement of rape victim under mental trauma. Which one of the following statement is correct? Investigation is made by police officer. The object of police investigation is to collect evidence. Investigation is not a judicial proceeding. The object of investigation is to collect the evidence. The object of investigation is to collect the evidence against the accused. Under section 159 of CRPC, a magistrate has power to depute any magistrate subordinated to him to hold a primary inquiry, direct investigation by the police. In which section of CRPC it is provided that a male child below the age of 15 years cannot called at a police station. Section 160 clause 1. A boy aged about 14 years is suspected to commission of an offense of murder. He can made to join the investigation at his residence. The investigating police officer has summoned to power the attendance of a person acquainted with the fact and circumstances of cases under section 160 of CRPC. A magistrate under section 159 can direct the police to hold the investigation. A person can be summoned as witness under section 160 of CRPC. A police officer investigating the case. The right against the self-incrimination under Article 20 Clause 3 of Section 161 Clause 2 of CRPC was recognized by Supreme Court in the case of Nandini Sampath versus P.L. Dani, under which section of CRPC investigating officer record the statement of witness. Section 161. Statement of a witness recorded during investigation under section 161 of CRPC cannot be used at the criminal trial except to contradict the witnesses. What is the distinction between section 161 and 164 of CRPC? Section 161 of CRPC, statement is recorded by police, whereas section 164 of CRPC, statement is recorded by magistrate. Which of the following is the ground on which a witness under section 161 clause 2 of CRPC may refuse to answer question may put by a police officer? Answer would have tendency to expose him to criminal charges. Answer would have tendency to expose him to a penalty. Answer would have tendency to expose him to a forfeiture. A refuses to answer question put to witness under section 161 of CRPC is an offence under section 179 of IPC. A statement recorded by a police officer during investigation under section 161 of CRPC can be used during trial for contradicting the witness. The recording of the statement by a police officer during investigation is provided by section 161 clause 3. Which of the following statement need not to be signed by maker? A statement under section 161 of CRPC. A statement under section 161 of CRPC are recorded by the police during investigation. A statement made by a person or by any person to a police officer in the course of investigation, it duly provided can be used by the accused and the prosecution of contradicting such witness. Power of a police officer to require attendance of the women witness in the cognizable offence extend to not calling that women to police station but going personally to the place where such women reside. Statement of the witness are recorded by police officer during investigation under section 161 of CRPC. A joint statement of a several witness recorded during investigation will neither render this person as incompetent witness, nor their evidence is inadmissible. Statement under section 161 of CRPC can be used to contradict the statement of the court. Can the statement of the witness recorded by police officer under section 161 clause 3 of CRPC be recorded by audio, video, electronic means? Yes. A statement recorded during investigation under section 161 of CRPC used during the trial for contradicting the witnesses. This section of CRPC provides that no statement made by any person to a police officer in course of investigation shall be reduced to writing, be signed by person making it. Section 162. Any statement made by a person to police officer under section 162 of CRPC in course of investigation may not be signed by the person making it. To say the photo identification is hit by section 162 is wrong. It has been held by Supreme Court in Musahar Khan versus State of MP. Who among the following is authorized to record a confession statement under section 164 of CRPC? A judicial magistrate. A voluntary confession is admissible in the evidence when made to the magistrate having competent jurisdiction. Section 164 of CRPC provided a special procedure for recording of confession as well as statement made during the course of investigation. If a magistrate administers oath before recording to confession of an accused, the confessional statement is bad in law and inadmissible in evidence. Who may record the confessional statement under section 164 of CRPC? Any judicial magistrate. A confessional statement recorded in accordance with the special procedure under section 164 of CRPC can be used as a substantive evidence without being formally provided. Who may record a confession of any statement made to him in course of investigation? Any judicial magistrate. Section 164 of CRPC provides about which one of the following recording of confession and statement. A is suspected of the commission of an offence of murder, trial whereof can only be conducted before the court of session. A appeared before the Metropolitan Magistrate and moved to the application for recording his statement under section 164 of CRPC. The grant of pardon. Who has power to grant the pardon? A Metropolitan Magistrate. A special procedure is provided under section 164 for recording of confession as well as statement made during the investigation. Section 164 of CRPC contains a special procedure relating to the recording of confessions and statement in view of provision which one of the following correct preposition. Any metropolitan or judicial magistrate may, where jurisdiction or not in the case, can record the confession or statement made in course of investigation. A confessional statement under section 164 of CRPC can be recorded during the course of investigation or at a time afterward before commencement of inquiry or trial. Which one of the following may be recorded confession under section 164 of the CRPC? Any metropolitan magistrate or judicial magistrate. obtaining signature of an confession of a person making confession under 164 is mandatory. Confession of the accused recorded by the magistrate under section 164 of CRPC shall be signed by him. The genuineness of the document not presumed if it is statement of witness recorded by judicial magistrate under section 164 of CRPC. A confession made under section 164 of CRPC can be recorded by magistrate during the course of investigation but before the commencement of inquiry or trial. A statement under section 164 of CRPC may be recorded by a judicial magistrate or metropolitan magistrate. Who can record the statement and confession under section 164 of CRPC? Judicial magistrate. Which one of the following is not an essential procedure requirement of section 164 of CRPC, namely recording the statement in the presence of advocate of the accused? Judicial confession can be recorded by the following procedure prescribed in section 164 of CRPC. Who can record a confession and a statement under section 164 of CRPC? Any metropolitan magistrate or judicial magistrate irrespective of his jurisdiction. Which of the following is not a duty of magistrate while recording confession under section 164? Duty to record confessional statement in the form of question and answer. Confession is recorded by judicial magistrate with or without jurisdiction. A non-confessional statement recorded under section 164 of CRPC is not a substantive piece of evidence. A statement of a witness recorded under section 164 of CRPC procedure can be used for both corroboration and contradiction. A magistrate records a confession of the accused of the statement of a witness during the investigation under section 164 of CRPC. Section 164 of CRPC provides the procedure of recording of confessional statement. Which provisions under CRPC deal with the procedure to be adopted by the magistrate recorded confession and statement? Section 164. Consider the following statement. A registered practitioner employed in a hospital run government by local authority. Any registered medical practitioner with the consent of victim under some special circumstances. The medical examination of rape victim shall be conducted by these two. Under section 164A of CRPC, the victim of rape shall be sent to registered medical practitioner for examination within 24 hours of the time of receiving the information relating to the commission of such offence. During investigation of the offence of committing rape, medical examination of alleged victim may be done with the consent of such woman, victim, or any person competent to give such consent on her behalf. During investigation of search can be conducted without warrant by investigating officer. When the search is required to be conducted outside India, the criminal court may, under section 166A of CRPC, issue letter of request. Under CRPC, to what maximum period of the accused can order to be kept in police custody by the magistrate? 15 days. When the investigation cannot be completed within 24 hours, the largest period for which an accused can be remanded to police custody is 15 days. When the investigation cannot be completed within the prescribed period of 90 days and 60 days, as the case may be, the accused is in the custody on expiry of the said period. If he is prepared to does not furnish a bail, the accused is entitled to release on bail by the concerning magistrate. Under CRPC, the accused person can be remanded to be police custody for not more than 15 days at a time. When the maximum period of detention during investigation for offense of murder, after which one is not filing the charge sheet of accused, is entitled to be related on bail 90 days. For the purpose of section 167 clause 2 of CRPC, the period of 60 days or 90 days will be renowned from the dates of producing before the magistrate. If the investigation is not completed within 90 days or 60 days, as the case may be, and the accused is in the custody of expiry of the said period, the accused is entitled to release on the bail and making the application for release on the bail. The accused is indefeasible right to bail when the investigation is not completed within 15 days. The authorizing detention of the accused is the custody of the police of the accused must be produced before the magistrate in person. A magistrate can be authorized the detention of accused in police custody for a period of 15 days. When does this period begin to run? On the expiry of 24 hours of his arrest. Under 167 of CRPC, the magistrate can authorize to detain the total period of 90 days during investigation in the case of offence punishable with death, imprisonment for life, imprisonment for the term not less than 10 years. A is arrested and detained in custody on the accusation for the offence punishable with the imprisonment for life. He is entitled to statutory bail as provided under subsection 2 of section 167 of CRPC after the expiry of 90 days. Where the investigation is not completed within the stipulated period of 90 and 60 days, the case may be accused who has been given custody on expiry of the above mentioned period get entitled to be released on bail and making the application of release on bail. Under 167 of CRPC, the magistrate can authorize detention for a period of 90 days during investigation in the case of offence punishable with death, imprisonment for life, imprisonment for term exceeding less than 10 years. Choose the wrong statement. A is wrong. Right is, under section 309 of CRPC, magistrate can remand the accused for maximum period of 15 days. Under section 309 of CRPC, even prosecution may be directed to pay the cost of adjournment. At the request of the accused, the court shall be not grant adjournment, enable him to show the cause of the sentence. Under section 167 of the magistrate can order detention in judicial custody. One of non-completion of investigation, the failure of prosecution to file a charge sheet within the prescribed period of 90 and 60 days as given by section 167 of CRPC, the accused person shall be released on bail if he has prepared to or does furnish bail. Bail granted under section 167 clause 2 of CRPC has same incident to grant a bail under section 33 of the code. Under section 167, the nature of custody can be altered from judicial custody to the police, and vice versa. The alteration can be done during the period of 15 days. A magistrate may not remand the accused to a police custody for more than 15 days. Which one of the following statement is correct relating to bail under the provision of section 167 clause 2 of the code? The right of bail does not survive after filing the charge sheet. The maximum period for which an accused can be remanded in police custody is 15 days. For the purpose of the computation of the period of 90 days and 60 days, as the case may be, the purpose of section 167 of the Code of Criminal Procedure of the arrest of the accused and the date on which the accused was remanded is different for both having the excluded. The executive magistrate is empowered to grant remand under section 167 of CRPC 1973 for the maximum period of 7 days. Section 167 of CRPC provides that the nature of custody can be altered from judicial custody to police custody, vice versa. This alteration can be done for a period of 15 days. This section of CRPC deals with the case diary. (172) Maintenance of the case diary by an investigating officer is mandatory. Section 172 of CRPC required the statement of witness recording during the course of investigation under section 161 shall be inserted in the case diary. Under which section of CRPC investigating officer has maintained case diary? 172. Police diary of the investigating officer is necessary under section 172. Offense at a place A investigated by police, at B cognizance of judicial first class magistrate, at B whether investigation and cognizable not without jurisdiction. After completion of the investigation, the police officer is to be submitted final report to the magistrate. The magistrate is not bound to conclusion drawn by the police and may order to further investigation, may sue a process against the accused person. After an investigation pertaining to the offense of murder, the police file a cancellation report. The report can be accepted only by the magistrate. Whether after forwarding a report under section 173 of CRPC, the concerned magistrate, the police can continue investigation in the case yes. A police report under section 173 clause 2 of CRPC must contain the particulars such as name of the party and name of suspect of the accused, nature and the information. Which one of the following provision of CRPC provide that investigation in the relation to the rape of child may be completed within 3 months from the date of which information was recorded by the officer in charge of the police station? Section 173 1A. Section 173(8) of CRPC deal with further investigation. 1. Completion of investigation. The officer in charge of a police station shall forward the police report under section 173 clause 2 of CRPC to magistrate empowered to take cognizance of the offense. Whether investigation based on a FIR relating to the same incident is permissible under law? No, not after forwarding the report under section 173 clause 2 of a previous occasion. Whether the police submit a final report under section 173 clause 2 of CRPC for dropping the proceeding to magistrate, the magistrate may accept the same, may reject the same and order further investigation. Charge sheet filed under section 173 of CRPC is example of public document. Section 173 1A mandate that any investigation into the offense of rape with child may complete within 90 days from the date of recording of information. Ordinarily, the place of trial of an offense is where offense is committed. A charge or in the case of merger of the complainant with a police report, the procedure to be followed for a trial shall be the procedure in the case instituted on the police report. Which section of CRPC 1973 applies when officer in charge of a police station receive information that person has committed a suicide? Section 174. Who will inquest the suicidal death of a woman within 7 years of marriage? Only judicial magistrate investigate, executive magistrate. The inquest report must contain the apparent cause of death. What is primary object of the inquest report under section 174 of CRPC? To know the apparent cause of death. Under section 174 of CRPC, when the officer in charge of a police station receives the information that a person has committed suicide or has been killed by another or by the animal or by machinery of the accident or has died under circumstances raising reasonable suspicion that some other person has committed an offense, he shall immediately give intimation thereof to the nearest empowered to hold inquest, executive magistrate. Not correctly matched is C. Correctly matches conditional order for removal of nuisance 133, security for keeping peace and conviction 106, power of use issue order and urgent case of nuisance 144. Which section of CRPC applies to when the officer in charge of a police station receives information that a person has committed suicide? He will immediately report to the executive magistrate. Section 174. Which one of the following section of the Criminal Procedure 1973 is when the officer of police station receive any information that a person has committed a suicide? Section 174. Under which section of the CRPC a magistrate has power to inquiry into the cause of death? Section 176. Which one of the following subsection was inserted in CRPC 205 of 176 of CRPC? 176 1A and 176 5. Which is true about recording of confession by magistrate? The magistrate should warn that it is not necessary for accused to confess. In case of Madhubala versus Suresh Kumar 1997, Supreme Court of India held that whenever the magistrate directs an investigation on the complainant, the police has to register a cognizable case on that complaint, threaten same as FIR and investigate into the same. where the person dies or disappears or woman is raped while such person or women in custody of a police authorized by the magistrate, a inquiry in addition to the inquiry or investigation was held by the police shall be held by a judicial magistrate in whose local jurisdiction the offence has been committed. When the confession of an accused person is not recorded in manner provided at section 164 of CRPC, the oral evidence of the magistrate is not admissible to prove that confession was so made was held in state of UP versus Singhara Singh. A magistrate has power to direct the police to investigate in respect of offence under IPC under any local or special law. Which one of the following statement is wrong? Court can suo motu order further investigation even after the charge is framed is wrong. Further investigation can be ordered on the application of victim. Further investigation can be ordered on the application of accused. Police can conduct further investigation even after the charge is framed. Which one of the following statement is correct? Under section 161, the statement of an expert may be recorded. In the summon cases trial by a magistrate, continuance of the investigation beyond the period of 6 months from the date of arrest of accused without the previous permission of the magistrate shall not render the entire investigation but accused is liable to discharge. Investigation is conducted by police. Magistrate cannot interfere in the investigation. Investigation is not a judicial proceeding. In which one of the following cases it was held that the person has right to protection under section 161 clause 2 of CRPC against question and answer of which have been tendency to the criminal charge. Nandini Sampath versus PL Dani. What is the maximum period of executive magistrate may authorize the detention of the accused in custody? Not exceeding 7 years. In which one of the following cases Supreme Court held that FIR was not a substantive evidence and could only be used to corroborate its maker? C. Mangesh versus State of Karnataka 2010. Any police officer making investigation can compel attendance of a person acquainted with the fact and circumstances of the case. Police report under Criminal Procedure Code 1973 is report of police officer on completion of investigation sent to the competent magistrate. What is the total period for which magistrate under section 167 clause 2 of CRPC 1973 can authorize the detention of person accused of an offence punishable under section 304B 180 days? An investigating officer during the investigation record the statement of witness under section 161 of CRPC. Under section 167 of the CRPC, maximum period of police custody of the arrested person is 15 days. In which one of the following cases is related to defective investigation? Zahira Abdullah Sikh vs. State of Gujarat. In which one of the following cases did Supreme Court hold that appropriate case police officer had duty to conduct the plenary inquiry before the registering the FIR in order to find whether the allegation may have been substantial or not? Rajneedhar Singh Khatoi versus Chandigarh administration. Corpus delicti would means commission of crime.